Yes, Mr. Young.
Morning, my lords. I appear for the appellant, together with my learned friend Mr. Rowbottom, sits behind me for Miss Sullivan, who appears on screen.
Yes, well, what we normally do, simply so it's not a distraction for us, is we ask for our camera to be turned off. Obviously, Sullivan can continue to see us.
Well,
sorry, have you not been asked to do that? It's not the end of the world. No, we're not that easily distracted.
Mr. Fergus McCombie appears together with Miss Louisa Simpson for the respondent counsel. Mr. Robert Moretto for the first intervener, the Department of Business and Trade. Miss Claire Darwin, King's Counsel, and Mr. Nathan Roberts for the second intervener, Protect. My lords, you ought to have the following bundles: a core bundle, a supplemental bundle, an additional bundle which contains the Protect skeleton argument as well as...
Yes, I have for some reason managed to leave behind the supplemental bundle, but my clerk will bring it.
And two bundles of authorities. I will refer to the appellant as the claimant for ease of reference. There is before the court an application. My lords, be pleased to note that that is not a live issue. My learned friend has agreed to those documents going in. The court will, of course, apply whatever weight it sees fit to that. There have been some emails yesterday evening, which you may or may not have seen, raising a costs issue. My proposal is if that...
The court will wish to read it. Well, we will read them, but the extent to which we will find them relevant is another matter.
Precisely. I ought to say, in fairness to my own friend, he's made the point that the accuracy of those documents, save for the specific documents, the accuracy of the matters is contested. In terms of timetable, it's anticipated the claimant's submissions will last till around 3:30 this afternoon. The respondent will take up till about midday tomorrow in the interveners.
I think we'll surely want to hear Protect before we hear the respondent.
Well, that's entirely a matter for...
Well, because otherwise the respondent won't have an opportunity to answer any submissions from Protect, who I think have half an hour.
Well, and then friends will have heard that, and you can go.
That must. I don't know what you were expecting, Ms. Darwin, but I think that must be right.
I think, my lord, we had agreed a timetable whereby the first intervener would go before me and I would then respond to the first intervener. But I'm in your lordship's hands.
Well, broadly speaking, the way I see it is that the respondent must have the opportunity to respond, because the appellant will have the last word, must have the opportunity to respond to potential adverse submissions. And clearly Protect submissions are not on its side, not on its side. So we'll do it that way. Then I would have thought, but it doesn't really matter, but I would have thought the respondent, and then finally Mr. Moretto.
My lord,
reply.
I'm obviously relaxed either way.
Yes. Can we just say, or clearly this is more than a one-day case. We'll be slightly surprised if it's a two-day case, and we'll be slightly surprised if it's going to be necessary for you to be effectively nearly all day. Well, we've read the papers, we're familiar with a lot of the authorities, but let's see how we go.
Well, my lord, I'll do the best I can to be more quickly than that, having
we'll see.
Indication. My lord, very briefly, my lord is aware of the issue. The claimant's case is that, contrary to Article 14 of the Convention, she was discriminated against in relation to the protection afforded to her in respect of her rights under Article 10, and in particular the protection for whistleblowers. And that was by reason of her status as a job applicant compared to others in analogous situations, and further that such discrimination was not justified, and that it's possible to read down primary legislation to enable both her and those with the same status as her to bring claims in the tribunal. I'm going to adopt the following structure. Firstly, I'm going to deal with a factual issue which has arisen in respect of grounds 2 and 6 with the EAT paragraphs 34 and 42.
That one I think was the tip lady point.
Yes, the tip lady point.
So, whether it's a factual issue or a legal issue is another matter. But
well,
and then with that issue,
it's developed into the facts, my lord. It's a legal issue in that sense. I'm going to then do a brief overview of the extent of the current domestic protection for whistleblowers, then the issue of status, then the issue of analogous situation. My learned friend, Mr. Rowbottom, will deal with justification, and I ought to say at this point, the claimant is content for this court to deal with justification. In our grounds, we suggest it should be remitted back. All of the materials before this court, and we're content. We will deal with that. Mr. Rowbottom will make submissions on behalf of the claimant in respect of that, and then I will come back and deal with reading down stroke declaration of incompatibility.
Very well, thank you. There were 2 or 3 documents which I think it'd be helpful for us to see by way of background. They are obviously summarised in the Employment Tribunal decision and therefore also in the AT decision. But if we mention them now, people can get on with obtaining copies for us. I'm assuming all of these were before the Employment Tribunal. I think they must have been because they're referred to. One is the letter to the claimant's MP. Second is, I think we would like to see a complete version of the council's complaints procedure rather than the extracts we have. And thirdly, we would like to see the email from the claimant, which is the one that they treated as the complaint. As I say, all those documents are summarised, but I think we'd like to see the documents themselves since they're central to what happened.
Yes, perhaps I could...
Oh, yes, thank you. And I'm reminded by my lord, there has been further proceedings in the Employment Tribunal on the complaints that were allowed to proceed. I think we'd like to see the decision of the Employment Tribunal on that matter as well.
My lords, anything I would say about that was, and I know the claimant was particularly exercised about that was the subject of an issue before this court, and the court wrote to the respondent indicating that if they wanted that before this court, they would need to make an application. And the reason for that is that case has gone to the EAT and is due for a full hearing on a specific point. I'm not across the detail of what the EAT position is in relation to that, but certainly no application was made following the court's invitation to do so last summer.
Well, I think it's a question of us rather than the respondent wanting to do it. The claimant can rest assured that we will understand that the findings in that, or the decision, is challenged. If on instructions, you may not be in a position to do it now, you want to tell us exactly what has happened in the AT and what the grounds of appeal are, we'd certainly like to be fully informed. It's simply by way of background. In a case like this, one wants to know everything, but we will not draw any adverse conclusions or inappropriate conclusions from seeing it.
Very well. Turning then to the first issue, which is the tip lady point. Yes. This arises out of the Employment Appeal Tribunal's findings, which are at page, well, the full findings at paragraph 42, page 114. Of the core bundle. In essence, and I'm summarising here, the EAT held that even if the claimant's arguments relating to the convention were sound, she failed on the facts because her claim wasn't within the employment field. In relation to that, we say several things. Firstly, this was not a finding of fact by the Employment Tribunal. There was no cross appeal in relation to it. There was no respondent's notice in relation to it.
Well, hang on. So these are 3 separate. 1, not a finding of fact. 2, no cross appeal. Well, no respondent's notice, stroke cross appeal.
And further, in the EAT, and this is in the supplemental bundle at page 33, at the end of my learned friend's skeleton argument, paragraph 31, in relation to disposal.
Now let's just
supplemental bundle, page 33. So that was and we say that's quite an appropriate and proper stance for the respondent to have taken, given the limited findings made by the tribunal. So in short, our position is the Employment Appeals Tribunal ought not to have made the findings it did. It ought to have remitted that issue back to the tribunal if that was still alive. And in any event, on the tribunal's findings of fact, on the material available to the tribunal, the EAT was wrong. And I put it no higher than this, but it is certainly arguable, and there aren't sufficient findings, but it's certainly arguable that the claimant fulfilled the employment field requirement. I'll deal very briefly, as my lord is obviously familiar with it, with Tip Lady.
Before you do that, it's not a question of the facts so much as it is the pleadings, because the particulars of claim, which is the claim before the tribunal, did not rely, or did it rely, on whether she was an applicant for a job. It relied solely on the accounting and taxation position of the trust. And then the first part of the judgment clarifies what the issue is. So it's not so much the facts or the non-facts as to what was the claim before the Employment Tribunal. So it would help us if you looked at or explained why the particulars of claim and the clarification of the claim is not the answer rather than the findings of fact, if you follow me.
My lord, I do, and my lord's right in everything my lord has said. What I say about that is several things. The findings of fact are important because the tribunal heard evidence as to what the claimant was saying. And rather than take my lord's tip, I can see that one doesn't need to go to that. Perhaps it would be helpful if I took my lord to the decision, the findings of fact in the tribunal decision. Yeah. That is in the core bundle, starting at page 125, paragraph 30. And just by way of preface,
one bundle, just one moment.
Just by way of preface, paragraph 29 limits the findings to the matters raised for the preliminary hearing purposes. But one starts with paragraph 30, the job interview on the 31st of October. Then the claimant is told on the 4th of November that she's not been successful. Then on the next page, paragraph 32, she attends a second interview on the 5th of December. Paragraph 34, she's told she's unsuccessful. Paragraph 35, on the 7th of January, she files an online crime report. And this is scene setting, but the claimant stated she had not raised a complaint with the respondent, but intended to email their safeguarding team relating to alleged statements made during interview. So that's a background as to where the state of play lay there. More detail is given in relation to a safeguarding complaint, paragraph 36. Then we move into February. On the 12th of February, she emails the chief executive of the respondent. And critically, we say, paragraph 39, the chief executive acknowledged receipt of the email, which he understood to be a complaint about the way in which the interviews were conducted. Ms. Shand, paragraph 40, is then charged with investigating that complaint, 39 and 40. Then we come to what the claimant relied on as her protected disclosure at paragraph 41. So she emailed Mr. Metcalfe and Ms. Shand advising her to contact the CQC and her MP, and she attached copies of those letters. Paragraph 42, the letter to the MP is the document relied on by the claimant as her protected public interest disclosure. In brief, the letter complains about the following matters. And there are two matters: comments made in interview, which we say squarely within the employment field, and B, the financial irregularities in the trust issue, except not on the face of it related to her employment.
Hang on 1 second.
So when the judge is making her findings of fact, she identifies the protected disclosures concerning two matters. Then we get into what happened in the summer.
We don't need to look at those for these purposes, do we?
Forgive me, my lord.
We don't need to look at those paragraphs for this purpose.
Only to say that 45, you will see, deals with the nature of the investigation and what the claimant provided in relation to that. She provided further details about what she said had happened at interview. And then we jump ahead to paragraph 51, which is the detriment relied on. What happened was Ms. Shand, who undertook the investigation for the respondent, investigated her complaints, including the complaints at interview, and then, and this is the criticism, told the claimant that she wouldn't be allowed to appeal that outcome.
Yeah.
So we can see, if we just take those findings, on the face of it, the claimant has made a protected disclosure concerning what she said in interview. Now bear in mind, we submit, the claimant was representing herself in the tribunal. She brought several claims, she had a lot of issues to deal with, and it's right, my lord has identified that the tribunal then went on to consider the issues at paragraph 18 and
paragraph 18
of the tribunal judgment, which is at page 121.
In paragraph 12, they begin by saying they're going to identify the issues by reference to the pleadings and the submissions. So you'd have to look at the particulars, and it'd be helpful if you had submissions to make on why the particulars were actually complaining before the Employment Tribunal about both the alleged financial irregularities and alleged breach of employment legislation.
Just before we do that, I respectfully agree. Shall we just see how the judge dealt with it, and then we can see? I think you were about to take us to paragraph 18.
I was. Just bear in mind. If one looks at paragraph 18,
That's when these are at 17 first. Tribunal clarified with the parties their respective positions with respect to any protected public interest disclosures. And sorry, then you were about to say
paragraph 1, the claimant confirmed.
Paragraph 1.
18, subparagraph 1.
Yes, I see.
The claimant confirmed, having acknowledged that the remaining disclosures identified were made after the alleged detriment. The refusal on the 18th of September to permit the claimant to pursue the appeal against the rejection of her complaint was the detriment. And the only alleged disclosure upon which she relied was contained in the letter to Mr. Justin Tomlinson MP. That was copied to the respondents on the 17th of March. So again, at that stage, the claimant is clarifying that the disclosures are contained in the letter. Now then what the tribunal does is say, whilst the main focus of this is to claimant's letter of that date related to the alleged conduct of the respondent during interviews, and that's important because that was the main focus of that letter, including what was allegedly said in those interviews. It also refers to the financial activities of the manager, Mr. Porter. And this is the point my lord has identified. The claimant confirmed that it's her case the reference to such matters in the letter constitute a qualifying disclosure, and then that is explained as being the fraud matters. What we say is that that is not entirely clear when one looks at the findings of fact, or nor the previous paragraph, because it's perfectly appropriate, when we say proper, to read those, certainly the findings of fact, as the judge making a finding that protected disclosure included both matters. In relation to the interview matter, we say that's an employment field matter. In relation to the point my Lord raised about the pleadings, the grounds of complaint are at 161 in the core bundle. They are, to be fair, somewhat lengthy and diffuse, but they do set out towards the end a detailed chronology.
But if you look at the first page, the assertion of paragraph 3 is by reference to the alleged financial irregularity. And in that section, up to page 163, is there any reference to alleged breach of employment legislation at the interview?
No, there isn't, my Lord. The point that we would make on that issue is this, that it is not unusual, indeed very common, for claimants who are unrepresented to produce a document such as this put before the tribunal. The tribunal then, in this case, did have a hearing in which the issues were clarified. And that happened here, I accept that. But equally...
Sorry, just to be clear, I don't interrupt your point. There was, in fact, a case management hearing before this hearing, but that doesn't seem wholly to have... That seems to have clarified the issues in the sense of setting out a structure, but it didn't finally clarify what the complaints were.
That's correct, my Lord.
Okay, thank you. So, not unusual,
So, as I say, the particular complaints, however, which are raised in this document. Page 170, paragraph 20 deals with the interview of the 5th of December. And a couple of pages before that, at 168, deal with the paragraph 15 deal with the interview of the 31st of October. Now, if one wanted to take a different approach as to what this actually says, what the claimant is saying here, and again, this would, if one took her complaint literally at this point, if one looks at paragraph 20, she is raising an issue there of the conduct of the interview being influenced by a protected disclosure, albeit in a different way that the tribunal ultimately finds. So if one were to take the pleadings, one can see that what paragraph 20, what she's saying, is that actually I made a protected disclosure about the Shanklin Trust, now subjected to a detriment at interview. That's what she appears to be saying there. Now, that's not the way we put the case today, but it comes back to a point my Lord raised about whether this issue was raised or whether the claim falls within the employment field.
Well, it was under the heading for reference only, and then that's why I imagined the tribunal clarified it.
Well, that's right.
One of the reasons why the tribunal clarified it.
My Lord, I don't seek to get away from paragraph 18 in the Employment Tribunal's decision. What I'm seeking to persuade this court is that really two things. Firstly, this issue is not something the Employment Appeals Tribunal should have addressed, because it was certainly on one view of the findings of fact, we say the only view of the findings of fact, an employment field case. And if, to the extent that needed to be clarified, it should have gone back to the tribunal for that purpose. And that's what the respondent said.
If it's a question of what the claim before the Employment Tribunal was about, then that's not a factual issue, is it, to go back? Well, that means reading the particular claim and reading what the Employment Tribunal found when it clarified the proceedings or the claim.
Well, as I say, and I'm not at risk of repeating myself here, it depends what part of the judgment you look at. Yes, one can see that when the issues were clarified, one had that issue clarified in that way. But that sits uneasily, I say, with a clear finding that the claimant's protected disclosure contained two issues. One, what happened to her in interview, and two, the fraud allegation. If you have that with a litigant in person and a respondent who's saying, in fairness, this issue should go back to be clarified by the tribunal, then it's, in my submission, would have been appropriate and a better course for the Employment Appeal Tribunal not to have revisited that. It is possible that on remission that matter might have been revisited. I raise that because just on a similar but related point, the employment judge in this hearing, for example, found that the victimisation complaint was within the employment field. But apparently, I know because I've now read it in the judgment which, at the full hearing, that finding was revisited by the tribunal at the full hearing.
I thought he actually said, but I'd have to read it, that it was better decided at the full hearing rather than he decided it was within.
Well, she,
by the way.
she,
Sorry, yeah. She decided that it was better left to the full hearing to decide rather than she made a ruling on it, but I'd have to read it again.
But be that as it may, it was certainly ventilated and canvassed and a decision made on it. The point I'm making, just by way of comparison, is it was obviously something, if this matter had gone back to a full hearing, as my learned friend rightly said, further findings of fact could have been made. The claimant might have said, well, actually, no. That's, what I was actually talking about was two aspects.
It's not really about findings of fact, is it? It's about how she chose to characterise her claim. I quite take your point that one has to be careful with a litigant in person in making sure they mean what they say and you understood what they really say. But it's quite clear that the employment judge did go through a careful exercise of analysing exactly what the claim is. And she reached a decision which we see in paragraph 18 about what the claim was. And that's not a question of fact, that's a question of reading the pleadings and talking to the claimant. And we can't go behind, surely, the employment judge's statement of what, having sought to clarify it with the claimant, she decided the claim was.
My Lord, ordinarily, I wouldn't resist that point, but one looks at paragraph 42, one has a completely different finding. Paragraph 42, page 127, identifies the letter to the MP. That is the document relied on by the claimant as a protected disclosure, and it complains of two discrete matters.
That's what the protected disclosure was. But when it comes to the tribunal, and she's now refined her case, because various things were said at various stages. For example, she suspected at the tribunal, at the interview stage, that they were worried about this, but then she withdrew it. So that's the fact. That's what the letter was. And the letter did, in fact, cover two things. But the question was, by the time she made her claim to the tribunal, what was she saying to the tribunal was the thing that she was complaining about?
My point, my Lord, is on those findings, she was saying to the tribunal, at that stage, looking at what that finding at paragraph 42 is, she was saying, I've got a protected disclosure, it consists of two matters. Now, I accept that at paragraph 18, the matter appears to have been clarified, but it's not clear, and there's no explanation in the judgment as to why that finding at paragraph 42 hasn't found its way. I'm not sure I can develop.
No, I take your point. You say there is an apparent inconsistency. There's no explanation. This really required, as a matter of justice, to be clarified. And quite how that would have been done, I don't know. Well, you go back to the employment judge and say, can you explain this discrepancy?
Well, my Lord, I think my learned friend's proposal was that we don't deal with the employment field point until it goes back to a full hearing. And
that may or may not have been. If I may say so, that's a separate point. I'm just trying to say analytically. That's not quite a separate point, but it doesn't really matter from this point of view, unless you're trying to raise some sort of estoppel, what the respondent's position was. It's more important what the right way of proceeding was.
Well, in relation to that issue, had the matter been remitted back, it was open to the claimant to invite the tribunal to revisit that issue, given that it was a full fact-finding exercise where evidence would have been heard, and these were findings of fact solely for the purposes of determining her entitlement to bring a claim, not for the purpose of determining the outcome of her claim.
Yes.
And it's not uncommon for matters to go back to a full hearing and to matters to be revisited.
Because is this your point? I mean, just making sure I've understood it. That these findings, though apparently explicit, for the purposes were made only for the purposes of essentially the Article 14 point, or what ultimately became the Article 14 point, the jury, and the employment field point had never been raised. If it had been, this finding would have been looked at more carefully. It didn't really matter for the purpose of the claim that was in fact the employment judge went on to determine. Is that a fair way of putting it?
Yes, and there's some support for that, my lord, at paragraph 29 of the tribunal's decision, page 125. Finding the fact solely for the determination of the preliminary issues identified above.
Yeah.
My lords, if my lords are content, I'll move on to the next topic, as it were. That's the overview of the legislation. Whistleblowing protection is contained within Part 4A of the Employment Rights Act 1996. If I can invite you to turn up the Authorities Bundle 1, Divider 2, page 10. It is, we say, important to understand the full breadth of the whistleblowing legislation, which certainly in the submissions of the intervener department appears to have been put in a rather narrow way, and I'll come to that in a moment. But the keystone of protection is section 43B, which provides for the qualifying disclosures. Several points to note. The disclosure does not have to be linked to a person's employment. It is not concerned, as the department have suggested, with protecting workers who discover wrongdoing in the workplace.
Well, I'm sure you're right, yes, I mean, but these points better made by reference to 43B, aren't we? Because 43A...
Sorry, I thought I was on 43B.
Oh, sorry, I thought you were 43A.
43B, yes.
Yes, no, I see.
43B, they don't have to be made...
So just give me the points again,
yes,
sorry.
So they don't have to be made in relation to the employment. They're not linked to employment. They can be made about any person in relation to any wrongdoing that satisfies the criteria set out there. That is, the reasonable belief criteria and the particular heads of wrongdoing. They are not concerned with protecting workers who discover wrongdoing in the workplace because they have access to specific information not available to the public. That is what is said by the department. There is no such restriction. And if we go through the legislation, if one turns to paragraph 43C, page 12, in relation to whom...
Hang on 1 second. You would accept, I think, that the typical case will be whistleblowing about something being done by the employer in the work context?
Well, there's no doubt that in most cases that is likely to be the sort of claims
Yes.
before the tribunal, but that doesn't impede the width of the legislation.
I can see that.
It's perfectly
But
possible
I just wanted to, yes.
to make.
No.
So
43C, you were about to say.
43, I'm now getting on to whom the complaint may be made to. So here we obviously can be made to the employer, but it can also be made in a case where the conduct concerns another person to that other person. 43D, page 13. It can be made to a legal advisor.
For the purpose of obtaining legal advice.
Yes, for the purpose of obtaining legal advice.
You can't just go off to any lawyer.
No. 43F. It can be made to a prescribed person, just provided the thresholds set out in subparagraph 1B are met. Page 17, 43G, provision for disclosure in other cases. Again, various thresholds set out in subparagraph B. And 43H, separate.
Yes, those are quite heavy. And there's no doubt the primary disclosure is meant to be to the employer or to one of the specified persons in 43. This is where you don't think that's going to work, or you think you're going to come to harm by doing so.
Or in 43H, which I've just taken to paragraph page 19, exceptionally serious failures. My Lord, I'm making the point here that, yes, we can talk about the typical case, but the legislation is broad in its ambit in terms of the nature of the disclosure and the person to whom the disclosure may be reported. It is, we accept, not protection for the public at large. We accept that, of course. It is protection in the employment field. It is wider than merely employees or workers because the definition of worker has been expanded in various ways, starting at 43K, page 21.
Before you do that, who does a job applicant, an external job applicant, have to make, if we read down worker to say worker or job applicant, to whom does the job applicant, the external job applicant, have to make the disclosure?
Well, there would be no change in the approach that the disclosure could be made to anyone. What matters, and this is the critical thing, the detriment to which that person was subjected would have to be by the putative employer. So that's the connection. It doesn't matter to whom the disclosure is made, it's to whom the applicant is subjected to a detriment, by whom so if
you apply to employer A and you think employer A at the interview did one of the specified things, breached a legal obligation, so on, does the job applicant have to go to that employer? Or if the job applicant raises it in an interview with employer B and mentions this, I had a terrible experience with employer A, and employer B says, I'm not going to employ you. Can she make a predictive against them? And who sorts out that problem then?
Well, it's no different in the current position that an employer, the employer who subjects the person to the detriment is the employer who carries the liability.
No, you're supposed to make if it's to know if it's a qualifying disclosure, it's got to be a disclosure made to the employer, for example.
Yes.
There are other things. So if you're a job applicant, whom do you make the disclosure to in order for it to be a qualifying?
That would be sorry, I'm speaking across reference in relation to that specific provision. That would be the putative employer.
When you say, yes, putative, you mean the person to whom the application had been made.
Yes,
Right,
exactly.
first job.
Who will typically not have given you a job, though conceivably they could.
Yes. Well, there is, yes, and this is an anomaly which I'll come on to in the recent case in the Employment Appeals Tribunal of McClellan. This is important that the disclosure predated the employment. The applicant was successful and was held to be able to rely on that disclosure. I'll come to that case in due course.
Okay, well, let's park that for the moment. We need to look.
But yeah, well, as we're dealing.
You said the protection under this legislation is not for the public at large, but is in the employment field, to use your word.
Yes.
What do you mean by employment field, and what is the source for it?
Well,
I'm trying to understand the ambit of the protection that you're identifying.
the primary protection is for employees and workers, and that comes out of Section 47B, which provides, and Section 103A. But it's slightly wider than that, because as we're going to come on to at paragraph 21, the definition of worker has been expanded. So when I talk about the employment field, I'm talking about workers, employees, and the expanded definition.
But that's fine, but they're all people who are workers or who are jolly like workers.
Well, yes, they have that characteristic. Yes.
So I don't think that it's important you make that point, but it doesn't really affect anything of substance, does it?
Well, only to the extent, the reason we make the point that my Lord has raised with me is this. We are not saying by bringing this claim that somehow the court is being expected to expand the legislation beyond the employment field, if I use that broad term. A job applicant is, we say, squarely within the purpose of the legislation, in the sense
that's in a sense assuming what you have to prove, isn't it?
Well, we would say not, because it stands to reason. If somebody is applying for a job, the person who is interviewing is an employer. Employers are the people to whom protection in this particular legislation is provided in terms of guarding against that.
But if that was so, why isn't the statute give express protection to job applicants?
Well, it does.
It's clearly the intention of the statute. Ignore the NHS position for the moment. The intention of the statute is not to protect job applicants. You may say it should be, and that's what you'll be saying by reference to Article 14. But Parliament did not intend to protect job applicants. And to say that job applicants are in the employment field because they would like to become workers doesn't really meet the real point, does it?
Well, I'm not sure why it wouldn't do, my Lord, in the sense that there's two separate questions. So the first is what did Parliament intend by the legislation? In relation to that, our case obviously is that it is discriminated against the claimant, a person with status in an analogous situation in relation to that.
Absolutely. I get that point, but I mean, perhaps we're arguing unnecessarily. But just to say, well, it's obviously in the employment field. In one sense, it's perfectly obvious. A person who's applying for a job wants to be an employee or wants to be a worker. So to that sense, there's obviously a connection with employment. But in a sense, that's what the problem is. It's not the answer to it.
The distinction I'm making, it's not as if we're talking about people who are applying for housing or people who are applying for services.
That's a straw man. I mean, who's suggesting you are suggesting that?
But to take my Lord's point, we're talking about people who are applying for jobs.
Yes.
That's
yes. No problem.
I know you've had a lot of questions. May I just ask one to follow up on that? I'm concerned about whether or not something is a protected disclosure and the scope of the case. And I've got no views, I'm just trying to understand the scope. I understand that if you apply for a job with employer A and that person does things wrong, it'll be a protected disclosure if you make a disclosure to that employer about the way that they conducted the job interview. That's employer A. But if you go and make a new job application to employer B, and I know it's not this case, but I'm testing the scope, it wouldn't be a qualified disclosure to complain to employer B, would it, about what employer A had done, because you wouldn't be going to the person, the employer who'd done it, and asking that employer to do it. So you'd have to get into the extremely serious exceptions and
My
so
Lord,
on.
my Lord, no, because
Oh.
you would be raising with your, I'll call them the employer, you'd be raising with the employer to whom you're applying for a job wrongdoing by someone else, which is squarely within 43B.
Okay, so let's have a look at
And
that.
that, my Lord, if I can just perhaps illustrate the point, that is not a, it's quite in a sense a sensible approach, because of course you may have different companies within a group.
Yes, you may have subsidiaries or
Yes.
contractors. So where is it in 43B then that
Well,
it's covered?
43B provides that you, if one looks at, provides that a qualifying disclosure means a disclosure of information which, in the reasonable belief of the worker making the disclosures, tends to show one or more of the following: criminal offence has been committed, that a person has failed, is failing, or is likely to fail to complete.
Anyone in the world.
Anyone in the world. It could be the previous person you've applied for a job. You can go to this employer and say, they could say, why didn't you get the job at the last place you applied for? And you could say, well, I told them that there was fraud going on in their organisation and they didn't employ me. You've made a protected disclosure to the new putative employer doing that. And if that employer then refuses to employ you, and this Protect will pick this point up, I'm sure, in their submissions, but this is not, we submit, an uncommon scenario in certain
This is blacklisting with a small b.
blacklisting with a small b, exactly.
Yes.
And this is not uncommon, and that's why this is obviously an important issue generally.
It could go even wider than that, couldn't it? It's less likely, but it would be entirely possible to have someone who says, I know that in the industry that you work, there is a great deal of fraud and corruption. I've done some investigations, and I know that, I'm not talking about you, but I'm talking about, and the employer might say, "Oh, I don't like this person. They look like they're going to be trouble." Now, that wouldn't be blacklisting. It wouldn't be that I was fired by my previous employer because I made trouble there. It would be something much more general. But you would still say that would be a disclosure.
Well, I'm not entirely sure whether on those facts that would fulfil 43B in the sense that I think you might at least have to identify the person whom you're alleging it against rather than general. But yes, in principle, yes, that would be right.
Yes. Not very likely,
Not,
but in sense, I don't know whether it helps you or hinders you, but it makes your point. It's another example of your point that it doesn't have to be about the employer with whom you are employed or are wishing to be employed.
but that is no different than people who are currently in the workplace.
And I know, yes,
They can make those kinds of disclosures about any person in any somebody who worked to the employer for 5 years could say, it has come to my attention, I'm not talking about our firm, but these other firms are doing X, Y, and Z, and they can say, actually, we don't like the look of that.
Yeah.
This guy's a troublemaker.
Yeah.
I'm not quite following this. My Lord Justice Lewis asked a question aimed at understanding the ambit of the code, and you answered it by taking us back to section 43B, which is about qualified disclosure.
Well, the reason I did that, my lord, is that qualifying disclosure makes it clear that the disclosure can be to any person.
Yes, but if you rely upon that to define the true ambit, then this becomes a public interest argument rather than something related to the employment field. What we were trying to understand is how you define employment field and what you base it on.
Well, my lord,
because 43B1 isn't limited to employment field.
my lord, I'm getting several questions. I hadn't understood my lord's question to be focused on that. I understand my lord's question was, and I'll come back to what I said about that.
I think you were asked, to be fair, my two lords were asking different questions or interested in different areas.
But,
Yes.
perhaps I can deal with my lord's point head on if I can. The employment field, and we say that for this reason. This legislation covers workers and employees. It doesn't cover the public at large. But in the terms of worker, the definition of worker is expanded to cover categories of people who would not otherwise generally fall within the category of worker as defined in the Act. So that is in section 43K as a starting point, where it expands the definition, which is page 21 of the authority.
So it would apply to the situation where in the course of an interview you mentioned that you believe somebody potentially unconnected to the employer has broken a criminal offence. It could be quite incidental to any question. You could be asked a question, you would say, well, oddly enough, I know that so-and-so has broken the law and so on. And you make that disclosure to the person who is treated as the employer because it's in the course of a job interview. Whatever that disclosure relates to, on your analysis, that would be a protected disclosure. And if the employer, the one you've applied to for a job, says, I'm not going to employ you, you could bring a claim saying, the reason why you didn't employ me was because I mentioned in the course of the interview this particular breach by another person. That, you say, is the scope of the legislation.
Right.
So the only thing that limits it in this context is that the person to whom you make the application is that people who employ people and you've employed that person for work.
Yes, my lord, of course, it doesn't necessarily that means that person has a viable claim. They'd have to.
No,
they'd
I
have to
said that,
prove
make a
the
claim.
link.
But the limiting factors would be the fact that the person to whom the thing is said is a person who employs. And you are in some way subject to a detriment by that person, which realistically is going to be the job application being refused.
And that the detriment is in the capacity as the job.
As the would-be employer, yes.
Yes.
My lords, I can take my lords through sections 43K to 49B and C to explain the scope of the extended worker provision. I know that my friend from Protect's going to deal with that. I think I prefer, rather than do that, my lords have got the point that work has expanded and my lords can read the statute. Perhaps go to some of the authorities which show quite the scope of this provisions. The first authority I might take my lords to is Elston, which is in the bundle at Authorities Bundle 1, Divider 22.
Yes.
This is page 535. This is an interesting case in the facts. The claimant was made a protected disclosure to BP at a time when he was not employed by BP. He was employed by another company. He then was subjected to a detriment by BP. And BP sought to resist the claim.
Sorry, subjected to a detriment by BP while still not employed.
No, when
he became employed in the meantime.
Yes, he became employed. And the BP sought to resist that claim on the basis that he was not their employee at the time he made the protected disclosure. And if we pick the authority up at paragraph 32, this is the decision of Mr. Justice Langstaff in the Employment Appeals Tribunal.
What was the detriment, out of curiosity?
Failing to provide, not providing with a consultancy agreement.
Yes.
Now this is
32.
Yeah.
Yes.
Now, what this demonstrates is this, that if the claimant in this case had been working for anyone at the time she made the protected disclosure, she would have been able to bring a claim. It was
against her employer, the person she was working for?
Against the council in this case, because she's made the protected disclosure and has been subjected to a detriment by by the employer. Because what this provides is that
Sorry, I'm being slow.
a worker is protected.
I understand exactly what Ms. Justice Langstaff is saying. How do you say that would transfer to the facts of this case?
Well, in this case, it is said the protected disclosure was not made when the claimant was a worker. But the protected disclosure in this case, if the claimant had been employed, she wouldn't.
It's also said the detriment wasn't suffered when she was a worker.
Well, in relation, I'm talking about here about the protected disclosure. So in relation to that, that wouldn't have been an exclusion on the basis that she wasn't employed. If she's been employed by anyone, she can bring it. She has a valid protected
against
disclosure.
her current employer.
She has to be subject to a detriment by a current employer.
Yes, she's got to be in an employment relationship. And the fact that the events occurred prior to that employment relationship doesn't prevent her from suing her current employer.
I'm taking this in stages. That's the first part. We come back to the next authority, which is McClellan, which is the recent case of the EAT, and that is at divided.
Just to make a note on Elstone, sorry. Yes, sorry.
The next case is the Employment Appeals Tribunal decision in Elston, which is divided, authority is divided to, bundled to, divider 56, page...
You mean the Appellant? You said Elston.
Sorry, I meant the pen.
Yeah, it's 56, isn't it?
Yes, 56, page 2014. If we pick up the facts at paragraph 16 on page 2016, the claimant contended they had made 4 protected.
Which paragraph did you
16.
say? 16.
Claimant
Thank you.
if my lords were to read 16 through to 16 to 19 at that stage.
Yes, thank you.
So one can see the protected disclosures predated the appointment, and then the decision on that part of the case is at paragraph 31 to 33. I invite my lords to read those paragraphs at 2017.
Sorry, paragraph
31 to 33.
Thank you.
So, my lords, if one thinks about that, the facts there, and applies them to this case, the only distinction is that this job applicant was successful, whereas the claimant wasn't. In other words, a job applicant who is successful is protected in relation to disclosures made before their appointment. The job applicant who is unsuccessful is not protected. And indeed, it's the unsuccessful job applicant who is, we would say, most at risk. There are two other authorities.
Well, because the usual, though not the only form of detriment, is not getting the job in the first place.
Exactly. Yes, precisely. Although, as was shown in McClellan, there can be subsequent detriments if.
No, I see that. That's why I said usual, though not the only. Yeah.
I mean, it's quite possible that somebody raises an issue and the employer decides to take a chance, and then they raise the issue again and thinks, hang on a minute, we employed this person, let's end their probation or whatever. Raise the issue after they've been employed.
I'm just wondering where this argument goes, because all this shows at the moment is that the legislation requires the person to be in an employment relationship, and somebody who doesn't get to that stage under the legislation isn't caught.
Well, that's, my lord, we wouldn't be here if that wasn't the position, because our case is that the legislation discriminates in relation to people in analogous situations.
Right, so you're saying that's the analogous situation. This is for...
Well, I'll come on to that.
This is all laying the ground for points we will resist asking you submissions. It's all laying the ground for saying, look at all these other situations. When you come to analogous situation, you'll say there's no real difference.
Exactly, my lord.
Yeah, okay, well, so...
I won't labour this, save to flag up two other cases. I won't take my lords to them because my lords will be familiar. Woodward, which is in the bundle at authorities bundle 1, divider 15, 290, that extended detriments beyond the end of employment.
Yes, that was failure to provide a reference, wasn't it? Yeah.
Yes, and just a critical point in relation to that. The respondent makes a point about timing, in other words, that the protected disclosure was sometime after the interview and the detriment was sometime beyond that, 6 months later. That, we say, is not relevant. In Woodward, the detriment was 6 years or 8 years later. So the timing of it, that's an evidential matter. It's not a, it's not a point.
I didn't detect that being a key point.
No, I'm just flagging up. The next case, which I won't take you to, is Onyango. That shows that after the employment has finished, the former employee can make a protected disclosure.
Yes, that's the one that Judge Taylor refers to in McClellan.
Yes, exactly. So those two cases also extend the ambit. So I just invite my lord just to take up my learned friend for the department's skeleton argument, which is at the relevant paragraph, page 73 of the core bundle, paragraph 67. That we submit is to put much too narrow a focus on the legislation. If we take it in stages, it states this legislation seeks to provide protection to the public by giving workers. Well, pausing there, it includes people who are not technically workers.
You don't need to rub that point in. They are workers because they're deemed to be workers for the purpose of the legislation.
Who are aware of wrongdoing in the workplace. That's not correct. Wrongdoing can occur anywhere. And raise concerns internally. Well, I accept my lord's point, that's a typical case, but it's not the only case. So it's far too narrow a focus. It focuses on what I accept maybe the typical case, but the legislation, as I've endeavoured to demonstrate, is far broader than that. My lords, I think I've, Protector going to go over some of this ground, I expect, so I think I've done enough in relation to that issue.
Yes.
I'll now move on to the status issue. The Employment Tribunal and the Employment Appeals Tribunal both held that the claimant and job applicants generally did not enjoy other status as required by Article 14. The Employment Tribunal's findings were that was because job applicants were too wide and generic a group, and the EAT held that being a job applicant does not refer to a characteristic personal to the applicant, but is a status defined for what a person has done, in that case applied for a job. and also that the claimant was seeking to define her status by the discrimination she experienced.
I see you've got to deal with this point, and I'm not going to stop you at all. But it's a well-recognised phenomenon of all these Article 14 cases that the same arguments, ultimately, status tends to be determined by a person in an analogous position and or justification. They all flow into one another. But you nevertheless say that the particular arguments raised here are bad, and you want to show us why.
I do, my lord, and I'll take it quite quickly. I think the useful starting point is the speech of Lloyd Jones in the Supreme Court in the criminal injuries compensation case, which is at bundle 2, divider 42. It starts at 1328. It was concerned with people applying for CICA awards who had criminal convictions. But I invite my lords to read 1345, paragraphs 40 through to 43, and then 45. If I won't read those out.
No, very well. No, that's helpful. 40 to 43 and 45.
Yes.
Fifth was life prisoners, is that right?
My lord, yes.
Yes.
My lord, one can see laid out there the development of the law, and in particular that status does not have to refer to inherent or personal characteristics or acquired characteristics. It covers things such as differences in military rank, those who have planning permission or don't have planning permission, landlords and tenants in Clift, although not cited here. If one turns up Clift, which is in the bundle, one has examples of former KGB officers. My lords will be familiar with the
Sidabras, yeah.
Sidabras and so on. Significantly, the earlier case of RGM, which talked about concentration on what someone is rather than what they have done, is no longer, certainly does not represent the direction of travel of the court. And it's difficult to see if someone chooses to apply for a job, they wouldn't acquire status in the same way that someone who chooses, for example, to be homeless or to apply for planning permission or whatever it might be, is also covered. I've set out in my skeleton argument at 27 through to 28, page 27 to 28 of the core bundle, 33 to 35, examples of other cases. I don't propose to take my lords through those, save that I just flag up a couple of cases which are worth review. Matheson, status was accorded in that case to a child on the basis that they were hospitalised in an NHS hospital. And in JT against the first tier tribunal, status was accorded to a victim of crime living with her assailant. But that particular decision is useful for Lord Justice Legate's analysis at 1083 of the authorities bundle.
Okay, which bundle is that? That's the one we're in, yes.
Yes, that's bundle two.
1083 is JT.
Yes, it's
So when he was in this court. Yeah.
Yes, when Lord Legate was sitting in this court. Useful if one starts at paragraph 75. In the centre of that paragraph, one can see the description taken from RJM of the concentric circles analysis.
Never understood that.
I just haven't even got the tab yet. I'm much more basic. You will send circles. Which tab?
Tab 35.
Oh, right.
The
Oh,
first.
because I'm missing some of the index. That's okay. Yeah.
Tab 35, my lord, page 1083.
The concentricity comes to relate to the degree to which the characteristic relates to someone's person.
And also the degree to which that particular measure has to be justified. The more suspect the category in terms of race, sex, and so on, the heavier the weight of justification. The wider out in the concentric circle, the easier it becomes to justify.
So this is another example of the test not being compartmentalised.
My lords, yes, and also it's perhaps for our purposes demonstrates that just because someone chooses to apply for a job doesn't mean that they don't have relevant status.
The problem I've always found with status, for the reason I've already given it, hardly ever is the decisive point of the case. But we agree about the direction of travel. And there are lots of examples of things that are capable of covering it, but it's not quite clear what the parameters really are. What does it mean? What is the principle you apply if you don't apply any of the principles that appeared in the early case law?
Well, my lord, I think it's
I
perhaps.
think that's an unanswered question, or you would have taken us to the answer.
I think it's perhaps easy to say what it doesn't include, and my learned friend has highlighted the case my lords will be familiar with of Stormshire, which was an attempt to, in the employment law field, to say that discrimination claimants should have the right to claim interim relief. And Lord Justice Bean in Stormshire, which is in the bundle, held that wasn't a status case because the person was only relying on status on the basis of the claim they had brought, which is plainly even beyond the generous interpretation of status outside of that ambit. Well, we're not in that territory. We say, amongst other things, that job applicants already have status in legislation under the Equality Act.
The best point is that a status will include situations where a person has done something or had something done to them which differentiates them from other people. And the question is, are they being discriminated against because of that? And a person who applies for a job differentiates themselves from members of the public because the other people haven't applied for the job. Simple as that, really, isn't it?
I couldn't put it more clearly than that, my lord, and wouldn't seek to do so. As I say, the final point in relation to this is 2 points. First is that I've already mentioned that applicants have status under Section 39 of the Equality Act. And the second point is just because a group is wide and generic, as the tribunal find, doesn't mean they can't have status. Immigration status contains a whole raft of different people, as does homelessness. Moving on to analogous situation. The claimant has compared herself to two categories of people, internal job applicants and NHS job applicants. The Employment Tribunal held that the claimant was not analogous to an employee or worker who's become a member of the what was an internal job applicant rather. Sorry, I'll start again. The Employment Tribunal held that she wasn't analogous to a worker because a worker is someone within the workforce who has associated rights and responsibilities. And she was not analogous to the NHS job applicant because that concerns people with specialist skills who transfer between organisations where patient safety is paramount. The Employment Appeals Tribunal adopted those reasons and also added, for reasons I've already, that she wasn't analogous to internal job applicants because they're embedded in the workforce and not analogous to NHS job applicants for the same reasons given by the ET. Just starting with the law, I take you to the second bundle of authority, bundle 2, divider 33. Case
if it is divider 33, it's bundle 1.
Forgive me. I'm working on trying that, maybe my error. Page 1015.
McLaughlin.
The well-known case of McLaughlin, paragraph 20. The section starts at 1025. Can I invite my lords to read paragraphs 24 and 26?
Yes.
Just picking up several points, my lords, from those passages of Baroness Hale. Obviously, no requirement for an exact comparator. Better to approach the issue from the standpoint of justification. Don't look for similarities, but for obvious differences. And critically, we say in the context of this case, you consider the issue in the context of the measure in question. And what we say that means is you don't focus on job applicants against internal job applicants. So you focus first on the measure in question and work back from there. So you look at the measure, which is the protection, we say, of whistleblowing in the, I accept my Lord's observations on this point, but I use the term employment field. So you'd start, that's the point we start with. We look at, say, that's the purpose of the legislation. It's protection of people in the employment field. Are job applicants analogous in terms of that protection to internal job applicants and NHS job applicants? Internal job applicants are already employees, so that tells us nothing other than the fact they're already protected, because I say it tells us nothing because they're protected from day one. In fact, we now know they're protected before day one on the basis of McClellan.
Is that right? I mean, they must have had a contract of employment even before. I know that the first disclosure was made, but not if the employment contract had never matured and come into existence. So is it right to say they're protected before employment?
Well, they're protected from the first day of employment in relation to matters which occur pre-employment.
That's different,
right
yes.
way of putting it. So if one takes that as an example, a person on their first day of employment, it's a slightly unlikely scenario, but suddenly discovers another job they want to apply for and applies within a day or two, they can't sensibly be said to be embedded in the workforce or in any meaningful way. They've got a contract, but that's pretty much the extent of it.
Well, they have rights and duties by virtue of the contract.
Yes. But in relation to, as it were, embedding that they've got a contract, but that's the extent of it. There's no broader relationship than the existence of the contract. And if one thinks about different types of scenarios where internal job applicants may apply for roles, you could have somebody in an office in Edinburgh applies for a role in an office in London, doesn't know anybody there, doesn't know anything about the organisation beyond what they've been doing up in Scotland, and they apply down here, and they're really in no practical difference, in a practical way, different than an external job applicant. They're completely new to that particular office, they know a bit about the employer, but they don't know anything about the operation, and so on. We know also from Baroness Hale in Gilham that it's not enough to say that the legislation doesn't cover job applicants, ergo they're not in analogous situations. That's, I think, self-evident. It's not, one can't rely on the fact that legislation doesn't cover job applicants to say they're not in analogous situations. In relation to NHS job applicants, both the Employment Tribunal and the EAT, we say, have fallen into error by applying to those job applicants, NHS job applicants, criteria which does not exist on the basis of the statute. They have, both tribunals have said that job applicants who are protected by section 49B are those concerned for jobs concerned with patient safety. Well, that's not correct. Section 49B, which is in the authorities bundle at bundle 1 divided 2, page 36.
Oh, sorry. Yep.
Does not restrict job applicants for NHS posts to those concerned with patient safety.
We just see the relevant provision.
Yes, it's 49B2. I'll give my Lord some time to read that.
Well, 49.2 doesn't take long to read. 49B2 doesn't. And
the regulations, if my Lord would want to see those as well, which were made under this, takes the matter no further, but they're at page 103.
Let's not go to them unless they help. Yeah, your point is that the protection of Crawley's by section 49B and the regulations made under it is simply to anyone applying to an NHS employer. An NHS employer is defined in various ways, but those ways couldn't be patient safety role dependent. No. It doesn't say applying for any particular kind of job. No,
is
that right?
That's correct, my Lord.
Yes,
and I just, to add to that point, simply say this, that a procurement role in the NHS is, or a finance or admin role in the NHS, is no different to in terms of quality of the role or nature of the role to a person applying for a similar role in the local authority.
am I also right in thinking it's not limited to people who are or have been employed by an NHS body and is seeking to move to a different NHS body? It could apply to somebody who's an accountant at BP and then wants to become an accountant, I don't know, for an NHS trust in Wales.
Yes, exactly, my lord. It's not restricted to
random. Yeah.
It's not restricted to people who currently or have been in the past employed by the NHS. I think that's the point suggested by the department. It's not our reading of the legislation.
Whilst we have section 49B, am I right in thinking that if you're an applicant falling within subsection 2, the protection you get is defined by subsection 3?
Yes.
It's not protection conferred if you're an employee by section 47B.
No, my lord, it's not. It's protection
So
conferred.
it's rather more specific. It's related to the application process.
My lord, yes.
So that's why you don't ask to read into the statute words equivalent to section 49B3. Instead, you ask to, when we come to remedy, to amend the definition of worker.
Yes.
So that your client would be able to rely on section 49B. Sorry, not 49B. I beg your pardon. 47B.
Well, my lord, yes. I mean, I just hesitate with a slight word of caution on subsection 3. It's not as narrow as one may think. It discriminates against an applicant if it refuses the applicant's application. That's one, so refusing the job, or in some other way treats the applicant less favourably than it treats or would treat other applicants in relation to the same contract, office or post. Now, using the facts of this case, it might be said that in this case that if the claimant had not made the protected disclosure, but some other issue had arisen in the interview, that her case would be that she would have got an appeal. That's the factual basis of what her claim is. So that, if it had been an NHS post, you could argue would come within that she had been treated differently than some other applicant in the sense that when she challenged the fact that she hadn't got a post, she was denied the right of appeal. So it would still come within that, even on, if we'd been applying for an NHS post, even on those facts. It's not quite as narrow as it first appears, my lord. It's possible, and I think Protect may have suggested that there's a reading in of that particular section. I certainly don't think it causes the difficulty that might first appear. There's a subsidiary point on this issue, which I won't trouble my lords with too much, although I know it has been raised by the department, is that the EAT, we say, went wrong by their reliance on parliamentary debates to determine analogous situation. And that is dealt with in the core bundle by the EAT at paragraphs 37 and 38 at page 112.
Do you want us to go to those?
Yes, if you...
yes, of course.
Perhaps the start of page 38, paragraph 38, page 113 is the key point.
Paragraph of the AT?
38, page 113 is the start, just the first few lines of that paragraph, where the EAT explain the purposes for which they are using the parliamentary material which they've cited above. I can deal with the point relatively shortly, and it's this. The EAT obviously recognised that it wasn't appropriate to use the material to construe the legislation. That's why 38 says what it says. We don't deny that if one looks at some of the parliamentary material, although by no means all of it, it is certainly focused on problems within the NHS and patient safety issues coming out of various reports, such as Mid-Staffordshire report and Sir Robert Francis' report. That's obvious. But when the EAT were looking at this, what they were seeking to do was, in truth, construe section 49B, because what was being said by the judge was, when you look at analogous situations, we are looking at people who have applying for roles where there are patient safety considerations. Well, that's, with respect to the EAT, not what the legislation says. I've already made the point. So it's difficult to see how you can rely on parliamentary material for establishing analogous purpose when, in fact, the very legislation that you're considering didn't restrict it in the way suggested.
As you say, it's a subsidiary point.
It's a subsidiary point. It's not a big point.
Can we look at it for legitimate purpose, though, when we're doing stage 4, justification?
Well, I'll leave that to my learned friend. I wouldn't want to trample on his toes, and I'm about to hand over to him.
Yep.
I've got a view about that, but I think in case it's not we're not that item, I probably don't want to say it. My lords, it's been a bit of a canter through, but I've covered the first several issues that I was intending to cover. I'm going to hand over to my junior, Mr. Rowbottom, who will deal with justification.
Thank you. That's been extremely helpful, if I may say so, and succinct, if I may say so. Yes, Mr. Rowbottom. Oh, sorry, I'm looking in the wrong place. Yes.
My lord, as Mr. Jupp says, I'm going to deal with proportionality and justification. The way in which this has arisen, my lords, we have a supplementary skeleton you would have seen, which deals with justification only.
Yes.
As Mr. Jupp set out at the beginning of his submissions, we have spoken to our learned friend for the respondent and for the DBT to let them know that we no longer seek the matter to be remitted in order to deal with justification. We're happy for it to be dealt with here. Because the EAT found that there was a fundamental flaw with the way that the ET had dealt with justification in relation to not going through the bank MEDAT stages, it wasn't dealt with at all in the EAT, because the EAT, the view taken was it should be remitted. So we are something here afresh, if I might put it that way, in respect to proportionality and justification. If I could set out the way that I propose to structure my submissions on justification, they are particularly made somewhat in response to the intervention of the department, because obviously...
Yes, well, that's the realistic...
Yes, my lord. And of course, because the way in which convention discrimination arises in employment law cases is slightly adjectival, because they're private cases. In order for there to be evidence presented in relation to justification, it has to come from, normally from an intervener, unless there's a state defendant or respondent rather.
Perhaps you can just help on something that's actually troubled me. So I think we're in a perfectly sensible place, but I don't know whether either your experience or your researches have shown how often, in cases where there's a private law respondent, which will typically be employment cases, but there might be some other kinds of public law cases. Sorry, I should say a non-governmental respondent.
Yes, ma'am.
How often questions of justification have arisen, as here really for the first time in the Court of Appeal? Because, as you say, it is in the real world just not realistic to expect that in every employment tribunal a convention point is taken, that the employer is in a position, or the respondent is in a position to advance in a case on justification, at least insofar as it isn't apparent from the face of the legislation.
Yes, my lord. We don't have an answer to that, is the short one. I wonder whether my learned friends for the two interveners might be...
Yes, well, I've just flagged it up. At the end of the day, it doesn't matter, or it doesn't matter in this case, but it is a slightly unsatisfactory situation, particularly probably in the non-typical case where some sort of factual findings might be required.
Yes, my lord.
For it had to be done effectively for the first time in this court, or even in any other appellate court.
Yes, my lord, I take that point. One caveat to that, and I'm afraid I don't have the authority to hand because it wasn't something that I anticipated arising in this case, is that there's authority to say when an appeal court examines the proportionality of a statute, as opposed to an individual decision, that the appeal court looks at the proportionality and justification question itself. Of course, that doesn't take away from the fact that you're sitting here without this having been determined at a lower level.
No, quite. It's an interesting point you made, but as you say, it doesn't really meet the concern that
Yes.
it's not ideal.
May I just reach below the desk because I don't have a cup, my lord?
Sorry?
May I just reach below the desk to get my water bottle because I don't
Of
have
course,
a cup?
yes, we're not that picky.
Thank you very much.
I see also you haven't got a lectern, but perhaps since
Well,
you're computing.
I have a tilting iPad, which is fine.
Okay.
My lord, so the way I propose to structure my submissions on justification is as follows. Firstly, I'm going to deal with a series of issues in relation to the margin of appreciation. These particularly follow the points raised by the department in its skeleton argument. Secondly, I'm going to deal with the department's material that it relies upon. And I use the word material advisedly because in our submission it's not evidence in this, and should be differentiated in that respect from the evidence which has been filed by Protect. Thirdly, I'm going to deal with the bank MELAP criteria. Of course, there is an extent to which those, as with the Michalak or Gillam questions, can bleed into each other, the elements of the bank MELAP test. So, but then finally, I'm going to deal with the lack of evidence. In this case, we say the lack of evidence, that the differential treatment in question, whether on ground 1, internal, external, or ground 2, NHS applicant, non-NHS applicant, has been considered. And at those 2 points, I will come on to my Lord Justice Lewis's question about the extent to which one can look at parliamentary debates. There are 2 separate issues there. One is the extent to which you can look at parliamentary debates for the purpose of identifying the legitimate aim. And then one is the extent to which you can look at it for the purpose of the actual proportionality analysis. They're both helpfully dealt with by Lord Reid in SC, adjacent to each other.
So I didn't make a note of your point. One was
The factors going to the margin.
margin of appreciation.
So, firstly, the department says this is a manifestly without reasonable foundation case. That, if you need the reference, my lords, is in the core bundle at page 71.
Well, that's just a reference to their skeleton.
Yes, it's in the subheading at paragraph 55, and then it's also at page 72 in black and white, that this is a manifestly without reasonable foundation case. We say that's simply wrong. It's wrong because Baroness Haley and Gillam said expressly that in Gillam, which we say is materially indistinguishable for this purpose, for the purpose of the margin, that Gillam was, the argument was run that it should be within the manifestly without reasonable foundation category, and that was rejected.
Which paragraph of Gillam do you want us to look at?
My lord, that's tab 34, Gillam, which, as I currently understand the hard copy bundles to be just in bundle 2.
Yes, it's the last one in bundle 1.
The last of bundle 1, I beg your pardon. Paragraph 33, my lord.
Oh, I say it's the last. It's the penultimate. Oh, sorry. No, it is the last. Yes, sorry. Para 33. It's tab 34 on para 33. Yeah.
Oh, I beg your pardon.
No, I was confusing myself. Right. Yes.
So you will see at paragraph 33, page 1055 of the bundle. The respondent argues this is a case in which the court should allow broad margin of discretion for choices made by Parliament for 2 reasons. Firstly, because it's an area of social policy, in which the court should respect the decisions of the democratically elected legislature unless they're manifestly without reasonable foundation, and secondly, because the state in question is not one of particularly suspect grounds of discrimination, such as race or sex. I just asked Miles to read paragraph 34. And in actual fact, it may save time to read down to paragraph 36, because obviously we say Gillam is particularly apposite for the proportionality exercise in this case.
But all this says is there are some cases where they don't use the social or employment policy, and a much more important factor is whether or not Parliament has actively considered it, and where Parliament has not actively considered it, then you don't add any weight to parliamentary consideration. But to a large extent, it's obviously superseded by SC anyway, hasn't it, or explained by SC?
Well, no, to this extent, my lord. SC is explicitly a social benefits, a welfare benefits case, and that is clear from any number of the references in Lord Reed's formulation. My learned friend for the DBT refers to this as a matter of social policy. In Baroness Hale's judgment, it's social or employment policy, and we say that Gillam is clear binding authority on this court in relation to the application of the manifesto without reason.
Surely. Oh, I see. Yes.
I don't wish to put. I take all the points about the nuanced nature of the analysis, and
you're simply concerned with what you say is the extreme submission, that an old-fashioned submission that this is MWRF.
Yes, and also Gillam isn't mentioned in that part of the skeleton, so it's to draw my lord's attention to that it.
Yes.
And because there is nothing in SC, of course, that doubts what happened in
Well, I understand why you want to knock that point on the head, but it might be said that even if it's not automatically manifestly without reasonable foundation, nevertheless, these are matters of employment policy, which shades into social policy, as Lady Hale herself acknowledges, and that a low-intensity review is more appropriate there than in some other contexts. Sorry, yes, a low-intensity review.
Yes, Mother. We agree with the way in which Protect put this, which is that it's nuanced as coming from SC.
Yes.
There are any number of factors that affect the margin, but consideration of the relevant margin and the factors that go to the margin is of course crucial.
Okay, well let's move on to that. Just so Mr. Moretto knows where he is.
Yes.
I think the old-fashioned mechanistic, this must be manifested without reasonable foundation. If that's really still his case, he will have some difficulty persuading at least me, but I think my lords as well. But I'm not sure that's really what it's about.
Thank you, my lords. And we should say, of course, I'm not particularly here to make submissions as to the factors on the margin that go against us, but of course we can't submit this as anywhere near a suspect ground.
It is not a suspect ground, that's correct. Yeah. And do you accept, A, that whether or not Parliament has considered it is a relevant factor, and B, that Parliament has in fact considered this?
Yes to the first and no to the second one.
Right, okay.
Because when wondering, and it may be that you're. I'll try and move through the points because there are a few I wish
follow your structure.
There are a few I wish to knock on the head, but it may be that particularly my Lord Justice Lewis, I will go in detail through, subject to Lord Reed's restrictions.
You should, but we will wait. Yep. So far we're on margin of appreciation. You addressed us why the test is not whether it's manifestly without reasonable foundation, and you accepted it's not a suspect ground. Are you going to make some other submissions on why, which are relevant to margin, the intensity of review?
Yes, my lord. Can I go through the factors that we say are relevant to intensity of review? Okay. I should have said it in addition to the nature of the ground. This is primary legislation. But then, my lord, I move on to the factors that we say militate in favour of a stricter review or a narrower margin. Firstly, and this is a case a point made by Protect at paragraph 1, page 134 in the additional bundle.
What is the factor? With bated breath, what are the factors?
I beg your pardon. So, firstly, this is about freedom of expression, my lord.
Oh, right, okay. The importance of the interested question.
Yes, indeed. And secondly, this is about access to justice. Of course, that differentiates it from the welfare benefits cases, my lord. If my lords...
Well, hang on. Is it about that access to justice? I mean, that, again, that assumes you have a right. If a right has been properly not granted to applicants for employment, they're not being denied access to justice. Access to justice is about procedural or access to the opportunity to vindicate your rights, but that assumes there's a right in the first place, which is what we're arguing.
I perhaps shouldn't have used such an abstract term, my lord. That might depend on one's view of a right. But if I can put it this way, it's access to a remedy. In the same way that, for instance, discrimination is a freestanding wrong by its nature, but it only is attached through relevant parts of the Equality Act.
But hang on, doesn't my objection apply equally to that? If there isn't a right, you are not entitled to a remedy, so it doesn't matter you denied access to it.
We don't accept that, my lord. If one considers the wrong as in detrimental treatment for raising issues in the public interest, the question then arises whether the detrimental treatment is something for which a claim can be made in a tribunal. We say that latter part.
It can't be made anywhere else, can it?
Well, no, my lord, no.
You've still taken the viewpoint that it's a wrong and that it's a detriment. You're using language that says a state of affairs has existed whereby it is unacceptable to do this. And you're saying, and we've got nowhere to go. But the first question is it a wrong? Is it unacceptable to do this?
Well, my lord, it's we say contrary to the public interest in a wider sense that arises under the whistleblowing framework. But
that's not illegal. That's not a legal right.
It's not illegal, right, my lord?
Yeah, okay. Well,
I mean, I don't wish to.
I'm sure you have better points to this one.
It's one factor, my lord.
Okay.
An example of that being used as a factor, we say, by analogy, and I apologise for putting it in the bundle because it is a long case, is the recent Dillon case in the Secretary of State for Northern Ireland, which is about the Legacy Act. And there was a point about amnesties, effectively, for violent acts and deaths that occurred during the Troubles. There was an Article 14 point run there. It was unsuccessful, but, and you'll find the point in our skeleton argument, this is at tab 52, paragraph 496.
I'm not sure which bundle you're in to begin with. Are we in the
I
authorities?
beg your pardon. This will be, sorry, my lord, authorities bundled, second bundle.
Okay. So far I've got, this is primary legislation, but the strict factors indicated strictly, I've got 1, the importance of the interest at stake. 2, I've got access to justice or access to a remedy because it would be contrary to the public interest not to provide a remedy. That's your second factor. I've understood it properly.
Yes.
And Dillon is going to exemplify that, is it?
Well, Dillon's going to give an example of what I just submitted as a relevant factor being taken into account in the Article 14 process. It's at page 1822 of the authorities bundle.
So it's the sideline paragraph 496.
Yes.
Well,
yes, having
I'm not
taken...
sure I don't want to be in any way rude, but this is so far from our... In order to understand exactly what the arguments were and the point were in this on a completely different area, we'd have to look at this already more carefully than I suspect it's proportionate for us to do.
Yes, my lord, I take the point. And also, when it refers to vindication of rights, they are talking about the Article 2 rights.
Well,
So
exactly. It's Article 2 case. Okay. Well,
I've dwelt long enough on this point. I beg your pardon. But we say it's a relevant aspect.
What's irrelevant? The one that you initially packaged as access to justice, but
Yes.
you've slightly reformulated.
Yes.
Okay. So we got, as my lord says, we got two. We got the freedom of expression, importance of freedom of expression.
Yes.
The point we've just been looking at. Anything more on that, or are we moving to a third?
No, I'll move to a third, my lord. There is no evidence, we say, in this case, that the values or interests relevant to the assessment of proportionality were considered when the policy choice was made.
Well, can we just explore that phrase a bit
Yes,
further?
my lord.
When you talk about legislation, you've got SC and so on, you've got Parliament, they've done this. This isn't the Secretary of State adopting a policy, this is Parliament.
Yes, my lord.
So we can read the words of the Act and we can see, well, that Act has been defined to do certain things and not certain other things.
Yes, my lord.
And we know at a later stage amendments were made to extend it to include further groups. That's the first thing. So we can look at the words of the Act and the amendment and the history.
Yes, my lord.
Secondly, I thought SC said we could at least look at parliamentary debates to see if things were said. We can't mark it out of 10 because of Article 9, but we can look to see if things were said. And thirdly, there are other background documents that you can look at to consider whether they illuminate the reason.
Yes, my lord.
So when you say evidence, what are you saying evidence of?
Well, material within the scope of the legal principles that control the material you can look at in accordance with SC, that there is nothing within those as presented by the DBT. And I'm not here to say we can't look at the...
Can we just spell out what this is? So you're saying that when the Public Interest Disclosure Act was introduced in 98, was it? Whenever it was.
Yes, I'm not there yet, my lord. So I was just, we say this is one factor relevant to the margin. I'm going to come on to this.
I
It's
see.
obviously,
Okay, well,
What sort of evidence would you say expect to see in the case of an Act of Parliament then? What will we be surprised to find omitted? What sort of evidence are you talking about?
well, my lord, when one chases through the chronology of the material you have in front of you, it was in 2015 that the primary statute was amended in relation to the NHS provision. There were clear concerns raised in the Lords about the restriction of it to only NHS applicants. There was a commitment in a government consultation a year previously to look at the status of workers in relation to applicants. When the NHS regulations were brought in...
sorry, is this an exercise you were going to do later?
It is, my lord, yeah.
I think let's wait when you come.
And I'm still, I beg your pardon because it's...
No, don't worry.
not
So
moving quickly enough.
you're, as it were, borrowing in advance a point you're going to make more substantially.
One is
Okay,
always
so
in-
the third point is no evidence that this was considered. So this is relevant to the
intensity.
degree of intensity of review. Yeah. Okay.
The authority for that, if my lords need it, is JT and First Tier Tribunal in Lord Justice.
Well, we better have it, I suppose. But it's all, doesn't Lady Hale say that in Gillam as well? Maybe she doesn't.
One has to be careful to distinguish between lack of evidence as going to intensity of
Show us
review.
JT then. Show us JT.
So this is it. So, my lords, if you go to JT, which is tab 35, which I think will be just in your...
Yeah, it's the first half of the second bundle, yeah.
And it's at page 1086. I beg your pardon, actually 1087. If you move down to paragraph 90.
Was this legislation or was this a scheme made by a
Secondary,
minister?
this is the scheme, so
Not
secondary.
Parliament then.
No, my lord,
By
it's...
the minister and laid before Parliament.
Yes. But Lord Justice Leggett, as he then was, went through a series of factors relevant to intensity And you'll see at 90 the assessment of the values or interests relevant to the assessment of proportionality and the extent to which they were considered is set out clearly as going to
Well, as you
intensity.
say, it's useful to have it, but it's
Now, as with all things,
uncontroversial stuff.
Article 14, they bleed into each other, my lord. I was flagging it in
No,
relation
that's
to
helpful. Yep, thank you.
intensity of review.
Fourth factor.
Those are
So those are the factors. Those three factors are the ones which you say argue for high intensity of review.
yes.
Yes, okay, thank you.
The final preliminary issue in relation to the DBT's skeleton that I just want to raise is this issue of A and B and Secretary of State for Justice and the limits of Strasbourg's Article 10 jurisprudence, because in the DBT's skeleton argument it said that a finding of discrimination in this case may fall contrary to the principle in A, B and Secretary of State for Justice that domestic courts shouldn't go further than Strasbourg. We say that's simply wrong.
I don't remember that point, so I think if you're going to meet it now, which you obviously should, can you just remind us what A, B, and S? Were you going to say about to take us to it anyway?
I can take you to the DBT skeleton, or I can take you to AB.
Well, take us to AB for a moment.
Yeah. So AB. Is at tab 46. AB was a straight negative obligation Article 3 case about detention of juveniles and when it amounts to segregation of juveniles and when it amounts to inhuman or degrading treatment.
Yep.
At paragraph 54, which is page.
Oh, sorry. This is the Euler point.
It's the Euler point, my lord.
Yeah.
But it also bleeds into the relevance of the Article 10 jurisprudence that's relied upon by the DBT.
Yes, I see. Well, let me just see what it said. Does it say anything we don't know from Euler?
No, I mean, it's the latest and most authoritative
That's fine.
reassertion of it by
I
Lord
forgot.
Reid.
Let me just read it. Yeah, okay, well, that, as you say, that's the latest statement of a well-known principle.
There's also 56 all round many times, and also it ends up at 59, which I think is what DBT cited. It's not really controversial, is it?
It's not controversial. It doesn't apply to the Article 14 analysis in this case, we say, for the following reasons. This isn't a claim that the failure to provide whistleblowing protection to job applicants, external job applicants generally, breaches the positive obligations under Article 10.
I see. So are you really saying that basically the whole Euler line of authority doesn't really apply to Article 14? It only applies to breaches of the primary obligations.
Correct.
Yes, I see.
All we've got to decide is whether or not there was differential treatment, which they're not being able to justify.
Correct. When additional rights are made available in domestic
Yeah,
law.
well, I see that. We'll hear what Mr. Barretto has to say about that,
Yes.
but I've got that point well in mind. Thank you.
The next point I wanted to move on is the department's material.
Yeah.
The department has placed material before the court and it's made submissions on justification of proportionality, but it hasn't filed any evidence. And when I come to the chronology in respect of how the legislation has developed, I say that's of significance.
Well, can we just pause on that for a moment? Because like you, well, I think probably prompted by you, but it occurred to me nearly all the cases of this kind that I have seen before, there has been a witness statement, although very often the witness statement hasn't done much more than exhibit a lot of materials, but still there has been a witness statement, and sometimes it's contained substantive material that isn't in the materials themselves. And I'll obviously hear Mr. Moretti on this, but I won't have a chance to ask you. But there might be an argument that that's actually quite appropriate, particularly in the light of the clearer understanding we've had in SC. We're not here dealing with the justification for for policy, or even for rules made by secondary legislation, even if subject to approval by Parliament. We're dealing here with primary legislation. Would it be appropriate for a civil servant, because who else would it be, or indeed the minister themselves as a representative of the executive, to give evidence about the policy behind the primary legislation, because of the very distinctions that Lord Reid made so clearly in SC?
Well, the answer to that, my lord, is the evidential lacuna in this case, and the important purpose for which that evidence can be looked at is to justify the differential treatment. It's not, and I'll come to this, the legitimate aim is a legal construct, and it's permissible to look at Hansard for those purposes, but really it's a legal construct, and SC is clear on this, where the court looks at the legislation as a whole, as my Lord Justice Lewis said. But on the second point, on the Bank Mellat, the fourth thing,
on proportionality proper.
Proportionality. Yeah. What's crucial is the extent to which the difference in treatment has been considered. Now, in this case, we say there's clear evidence from Parliament that the difference in treatment was raised, or rather, but there's no evidence that the actual differential treatment has been analysed and therefore that it's been justified. Now,
how would you do that with primary legislation? You get 636 or whatever it is MPs to say what went through their minds when they went through the lobby.
No, my lord, and sorry, I wasn't clear. I was answering my lord's point in relation to an official giving a witness statement.
Yes,
we say that could well be done in this case, because what you will see is the DBT have put forward for recent material, the Employment Rights Bill and Labour's plan to make work pay. It can be seen from that there is no aspect of it that addresses job applicants generally, and there would be nothing prohibiting, and it would be quite proper for a civil servant to put a witness statement together for this court saying these are the policy issues we have considered in relation to whistleblowing in developing our...
But this is parliamentary legislation. It's not what some civil servant or some cabinet minister thinks. It's what Parliament thinks. And I thought, as he said, but you remind us, that you can look to certain things like white papers and so on to see what the mischief was. You look at the terms of the bill, and it's perfectly clear that this bill, which became that, was concerned with workers. That's what it says. And the question is the problem with it not applying to people who aren't workers? And what I thought SC said was, if it's clear that Parliament was aware of what they were doing, either from the terms of the bill or because there was a debate saying we're not extending it, then you can look at that. And the fact that the 650 members of Parliament have considered it, and they will have had their different views for voting or abstaining or rejecting it, that you assume and give great weight to Parliament's assessment of the fact that they chose consciously to enact a law which protected workers but not applicants.
My lord, and again, I should be moving more quickly because I will. There's a difference in the legal test for legal legitimate aim, which is what I'm about to address, and then one moves on to proportionality, and Lord Reed says at that
But
point...
why don't we part, this all came off my question about you being critical of the absence of witnessing.
Yes.
We can come back to that. Maybe the answer to that is obvious once we've had your full analysis.
Yes.
But the fact is, I agree. I was a bit surprised because normally you get a witness, so you just don't get a lot of documents. But then it occurred to me that this might be the reason. Anyway, there we are.
Can I give you this reference, my lords, because I'm conscious I'm not dealing with my Lord Justice Lewis's point, but I do intend to, and I want.
I'm sure he knows you're going to
move more quickly. So there is a succinct summary of the case law in relation to the burden being on the state to justify the discrimination and the lack of evidence in certain cases and what that does. That covers Reed Brewster, it covers misbehaving, it covers the relevant cases. That is actually referred to by Protect, and it's in the case of JP, the Secretary of State for the Home Department. It's tab 38. I don't wish to take you to it now.
It basically just says the burdens on the well,
and it highlights that when there is a lack of evidence filed by the defendant, one takes that into account.
Well, perhaps we better just look very briefly at what it says.
I wonder whether all of this hasn't really been overtaken by SC, but it doesn't matter.
I don't think I have endeavoured to make points that are relevant where they're not in SC.
Okay, where's the paragraph that you says, or paragraphs that summarises the pre-SC law?
So paragraph 84. Oh, I beg your pardon. It's page 1169.
Well, that's where that's the start of the case. Which is the paragraph that you say is.
Paragraph 155, which is at page 1198.
Was this a government policy or was this legislation enacted by the King and Parliament?
It's a government policy, my lord.
Government policy?
Yes.
Which paragraph?
So paragraph 155 to 159. Can I move on to the bank?
Yep.
Now,
thank you.
Back to the final. Firstly, the legitimate aim. The legal principles as to how the aim is identified, they are set out in SC, my lord. So that is tab 48 of the authorities bundle in bundle 2. Paragraph 172, which is page 1586.
I do beg your pardon, which paragraph again?
So 172, my lord.
Yeah. So sorry, I didn't get to that. Yeah, got it now, thank you very much. Yeah.
172 to 173. And if my lords read those two paragraphs. Because in my submission, it's important to identify the different parts of Lord Reed's judgment in SC where he's dealing with the different aspects of the test. This is the legitimate aim part. He refers there to the Countryside Alliance and Attorney General case. And I'd just like to take you to that, my lord. So that's at tab 17. That was a case concerning a challenge to the Hunting Act 2004. If I could take to paragraph 40 of it, which is at page 370.
Shall we just read paragraph 40?
Well, I'll take you through it, my lord.
Would you mind, nevertheless, if I quickly look at it and then let you take just at the whole?
It's in particular the House of Lords approved the divisional court's formulation of the legitimate aim.
Yes, so you don't think it's necessary to read to the end of 40? I will, but you're just saying that in substance, they approved that.
Yes,
right.
And the point being, it's a composite.
Yes.
Legitimate aim. It's general and expresses the aims of the provision as the Act as a whole. It, as was made clear in SC, wasn't stated explicitly on the face of the Act at all. That takes us back, my lords, to SC, where at paragraph 173, which I think you've just read, Lord Reid emphasises that considerable care has to be taken when considering the use of parliamentary materials in relation to the Human Rights Act. And so, in summary, the provision's legitimate aim is distinct from its effect. And
sorry, I just didn't hear that.
The aim is a distinct principle from its effect.
Yes.
It's a legal construct. And as per Wilson and First County Trust, again in that SC passage, it's the underlying social purpose sought to be achieved that's relevant. Regard may be had to parliamentary material, but it should not be determinative, and occasions when Hansard is necessary as part of the compatibility exercise will seldom arise. That takes me, my lord.
Where does it say the bit about the seldom arise?
So
I find it. Where does he say it will seldom arise?
That's in Wilson, which is cited in SC at paragraph 175.
Oh, I see. Sorry, I thought you were drawing a line under 173 because that's dealing with legitimate aim, and 174 is dealing with.
That's my fault. Let me. I think that might be an error in my speaking. Clear about that. I've been told. Yes, that's my error, my lord.
Don't worry, but I just make sure that
no, entirely my error.
Structure
Wrong place in my speaking.
Make sure I'm following this. In 172, Lord Reid says in line 2, it's an essentially legal construct rather than something which can be discovered by an empirical investigation. What does that mean? What's the contrast he's getting at there? What would an empirical investigation connote?
Well, in my submission, my lord, he's warning against, and this whole passage in SC is, of course, although it breaks up the use of Hansard for different purposes. It's warning against overuse of Hansard and trawling through, I think is a word that's used later on in the passage. And so
it seems to be saying you don't expect evidence. That's what an empirical investigation would refer to. A legal construct makes it sound as if it's the function of the court interpreting the statute. Isn't that the contrast he's drawing attention to?
it may be, my lord.
But
We say
if so, it would go back to my Lord Justice Lewis's question when you're dealing with an act of Parliament.
Well, I don't want to labour the lack of evidence point in relation to the legal construct legitimate aim point. We say it's acutely relevant when you come to the proportionality part of the justification assessment. We say that is because the extent to which the values have been considered isn't just a question of what was legislated at the time in this case. It's a question of the extent to which those values have been assessed as Parliament has developed the legislation over time. May I move on, my lord, to the legitimate aim that's put forward by the department?
So you're still on legitimate aim at the moment. You're not on proportionality.
No.
No, okay.
I mean, isn't it obvious from the Act before it was amended in relation to the NHS that, rightly or wrongly, the purpose of the legislation was to protect workers from being subjected to a detriment if they made what was defined as a protected disclosure? Isn't that the aim of the Act?
We say it's wider than that, my lord, because the courts that have interpreted the Act, and of course the legitimate aim is a legal construct,
Yeah.
the courts that have interpreted the Act have interpreted it wider.
Right. So it includes people who are workers. It can also bring in people who cease to be workers in respect to acts that occurred in relation to workers. It can include people who've got contracts of employment but have not yet turned up at the office for the first day of work. But the whole of the Act, if you read it, is concerned with the protection of those people who have or have had a contract of employment, and they've decided to protect such people from detriments widely construed in consequence of protected disclosures defined by the Act. It's rightly or wrongly, it's to protect those with the contract of employment from being badly treated because they do things that are regarded in the public good. That's all the Act is about, isn't it, in terms of aim?
It does protect workers using the 230 definition within a typical employment relationship, so work experience, agency workers, ones where there isn't necessarily a contract of employment.
Yeah, but that's all marginal. My lord's real point is, not just his point is, that although there may be some frills in exactly how you define workers, they are all people who have been in a working relationship with the employer, and that was the aim, was only to afford such people protection.
We have put forward a legitimate aim. Can I take my lords through the DBT's proposed one and why we say it doesn't work, or would you rather I move on to proportionality assessment?
No, do whatever you want. You've got to meet the DBT's taste. But what do you say the aim was? That's even more important than saying what's wrong with the DBTs.
So we say the correct aim, my lord, is...
Are you reading from your skeleton? Right.
Yes, this is in our skeleton, but I'm not reading.
Tab. Which para?
So
Which bundle and which paragraph? Which bundle?
It's the additional bundle, tab 6.
Bundle tab 6. I thought so.
bundle tab 6.
Yeah.
paragraph 14, page 105.
That's pretty broad, isn't it?
It is broad.
It's really a public interest objective, which I thought wasn't being pursued according to Mr. Jupp's submission.
We say there is, there's obviously the connection with the employment field, my lord. But it.
So you say, effectively, the aim is not quite as appears here, but that to protect individuals who make certain disclosures of information in the public interest in the employment field, or individuals do. Put the phrase
Yes,
in
it's
somewhere.
stated in our original replacement skeleton argument, my lords, which is in the core bundle at page 35. Paragraph 63.
Page 35. Sorry, this is your paragraph. 35.
Yes, so paragraph 63, page 35. As to the purpose of the legislation, to protect those who make disclosures in the public interest from retaliatory action by an employer or a prospective employer who enjoys the power.
Yeah, but in the sense you're accepting there that the aim is only to protect employees, but then you're saying that the same rationale ought to extend to applicants.
Well, the rationale can't apply to NHS applicants. So it's no answer to the second ground. The second ground.
No, we're not on the second ground at the moment. We're
Yes.
on
The purpose can't have been to protect applicants in 1998. By definition of the very fact it had to be amended to include a subset of applicants.
Of course, I
So
accept.
it must have been intended to protect people in a contractual relationship of employment from harm because they've made defined disclosures. It can't be for anything else at that stage. Whether it's justifiable or not is another question. But in terms of asking ourselves, what did Parliament mean to do? They did mean to protect people in the wider public interest if they say something and somebody does something bad to them. They were protecting people who were in the contract of employment.
Can I take I'll take you to the debates on the actual bill that was introduced.
I mean, this just shows, of course, the difficulty, even despite the fact we all respect enormously the Bank Bailout test, of carving these. Your real point is that, in one sense, this was the aim of the legislation, was exactly as my lord has put it to you, but it oughtn't to have been. The aim ought to have been a wider aim. Now, the Bank Bailout test doesn't allow you to put it that way, but
Could I take you to one part of the debate, my lord, when the bill was originally laid before
all
Parliament?
right. But I just want to get this out conceptually.
Yes.
Your case is that the actual aim of the legislator, you have to accept, was only to protect workers, with all the frills we've looked at.
In the original inception of it,
Yes,
pre the
all right,
NHS.
in the original inception. But that on the wider part of your case, the as against internal applicants part of the case, that to make legislation with that aim was in breach of Article 14 because it didn't afford the same protection to people in an analogous position without justification.
The second part of the question in my submission falls to be answered now. And the legitimate aim of the statute is a legal construct which has to be referred to now. Now, I accept that on our second round of discrimination, that it brings to light the fact that one doesn't have to be a worker in that sense. And I accept the original...
When you say your second ground...
Sorry, the NHS ground.
Yes, can we keep off the NHS ground for a moment? Because they are conceptually quite different.
Yes.
If your argument is right, it was in principle just as right in 1998, whenever the public interest exposure as it is now. Nothing has changed in the social environment.
No, I don't accept that, my lord.
Why not?
I mean, because when one looks at, so that's why I took my laws to Countryside Alliance. The question of discrimination must be looked at now. The aim of the legislation should be delineated, taking into account the legislation as a whole and the scope of the legislation as a whole. I completely take the point about what was in the scope of the original formulation of the legislation, but it's been amended.
All right, but I wish you would. I'm sorry, for my intellectual purposes,
Yes.
I want to understand whether you, on your on the non-NHS part of the case,
Yeah.
you are saying that the answer to this case will be the same in 1998 or as in 2025. I can't see why it wouldn't be, unless there have been some fundamental social changes such that the position of job applicants was very different now than it was in 1998.
There's no authority for hiving off legitimate aims. It depends on the provision that restricts it. But in terms of the legitimate aim that's been proposed by the DBT in this case, it takes into account the whole of the framework.
Yeah.
And that's what I was making submissions on.
Can't you overcome this problem very, very simply by saying, whilst the original aim in 1998 must have been to protect those in an employment relationship, by the time we get to 2015 or whenever it was amended, the aim of the legislation as amended at that stage was to protect those in an employment relationship and those who had applied for NHS employment relationship. That's the extent of it. The two groups of people that are protected by 2015 are those in work and those wanting to work in the NHS. It still didn't cover those who wanted to work other than in the NHS, and that's the purpose by 2015. So even if the purpose has been updated, it's still only been updated to include a subset of applicants.
Well, I agree with the first part, my lord. I was trying to say that the legitimate aim has been updated as.
That's why I'm trying to help you on that.
Yes, but I'm not allowing you to take advantage of that help. I want to know so that I can understand how this works conceptually.
Yes.
I want to ignore the changes that happened in 2015 and just understand, insofar as the comparison is with internal applicants, what the timing has got to do with it. Whether the claim is brought now. Legislation, unless there are fundamental social changes, legislation will be justifiable on day one and justifiable in year 20.
Not if there are changes in the way the legislation is read by the courts, for instance, which would change the remit of the legal construct fundamentally,
That's
potentially.
very odd. That would just show the courts were wrong how they interpreted it.
Well,
See, Strasbourg wouldn't make that sort of distinction. You're saying.
well, the legislation has been developed by the courts in this case.
Well, it hasn't really. It's just drawn out things that were always there.
Of course, my lord.
And anyone well advised pre-Elstone would have said the legislation covers an Elstone situation and a McInerney situation. McInerney, the recent McClellan.
Yes.
So I don't think the legislation has developed anything, has it? I mean, it's just drawn out what was always there.
Could I assist, Miles, by taking you to the Hansard part?
Well, I think we better do this after lunch.
Yes.
We've gone on rather. So let's say 2:05.
Wonderful.
All right.